It's harder to, if you lose at the magistrate level, it's more difficult to win at the appellate commission level for this reason. In the old appeal board days that ended in the 80s, the standard of review, and I don't mean to use a lot of big legal terms, but it was de novo, which means that everything the magistrate decided, or the ALJ as it was called then, could be re-debated, reanalyzed at the appeal board level. Everything, you can ask the appeal board to look into anything that you brought up at trial. And the appeal board could say, well, I think that the magistrate got this and this and this wrong. There were more opportunities, more arguments for you to win at the next level. Well, since the appellate commission has come into play, the legislature wanted to reduce the number of appeals by making it, giving less incentive to appeal. The appellate commission now is supposed to defer to the magistrate on many things, and that means that even if the appellate commission wanted to change the magistrate's ruling, they could not. Now, they're still allowed to in certain cases. They have to see, they're supposed to look at all the evidence, but if they see some substantial evidence that supports the magistrate's ruling, even if there's other evidence that could compel a different ruling, if there is enough evidence on the record that the magistrate did base their ruling on, the appellate commission is not supposed to disturb that. Now, there's also something called an error of law, and if the magistrate has misapplied a law or misinterpreted a law, that's a higher possibility of prevailing, but there aren't that many issues of those on appeal.
And at that Michigan Compensation Appellate Commission level, it's taking about a year or so from the time of making a claim for review of a magistrate's decision to disposition by the Michigan Compensation Appellate Commission. And once you get that opinion from that administrative appellate body, where does the injured worker or employer go then?
There are some other options, but they get increasingly futile. What we've discussed are the two levels within the workers' compensation agency.
Yes.
Your best bet to win is the magistrate trial level. The next one is the appellate commission. That's not a court per se. It acts like a reviewing tribunal court, but it's called a part of an agency proceeding. If someone is not content with what the appellate commission ruled on their case, either employer or injured worker, they can go to the next level. Well, they can try. The next level is the Michigan Court of Appeals. So it jumps from the agency into the court system. Now, for some people, such as a criminal, they get their appeal heard by the Court of Appeals in almost all cases. The Court of Appeals has to take certain cases. But the law specifically says that for workers' compensation, the Court of Appeals, and then even the next level, if either party wants to try there, the Supreme Court of Michigan may allow an appeal from workers' comp. They don't have to. So actually, if a party wants to try to appeal to the Court of Appeals, the first thing they have to do is to file this big document called a brief, which sets forth all the reasons why the lower rulings were wrong, and ask the Court of Appeals to take the review. If the Court of Appeals agrees with your arguments and takes the review, then you've got to submit another brief for the actual appeal. So the first attempt with Court of Appeals is just what they call an application for leave to appeal.
And if the Court of Appeals grants that application, then there's further briefing done and you proceed in the Court of Appeals like you would in the criminal law case, as you described.
Correct. But remember, let's backtrack one level. The appellate commission, if there is substantial evidence to support the magistrate's ruling, the appellate commission has to say we uphold the magistrate. At the Court of Appeals, it's even more difficult. The Court of Appeals rule is that if there's any evidence, it can be just a little bit of evidence that supports the magistrate's findings, the Court of Appeals is not supposed to upset that ruling. Really, the only real chance you have at a Court of Appeals level is if the magistrate or the appellate commission has misapplied one of those rules of law I talked about.
And if the Court of Appeals says no, there's not a legal basis to grant leave and to allow you to proceed to appeal a case before us, what remedy does the worker or the aggrieved employer have then?
Well, either if the Court of Appeals decides not to take your case, or perhaps decides to take it but then still rules against you. Any party that wants to take it beyond Court of Appeals may do the same thing with the Supreme Court, which is apply for leave to the Supreme Court. It asks permission. You do not get that automatically.
And I think a lot of even practitioners in other areas of the law, and certainly clients, are surprised to find out how often workers' comp specialists lawyers are in the Court of Appeals or state Supreme Court.
Or at least trying, yes. Are you talking about cases that are actually accepted?
Yes.
Well, that does happen more and more, you're right. Although, I've certainly been frustrated a lot of times wishing that they had taken them, and they don't always. But, yeah, your point is well taken, that people not familiar with the workers' comp practice may think that you never get outside the agency levels, but you do.
Or they might think that they never have their case come to a conclusion, and that's in part because there are these administrative and judicial appeals opportunities for either party. But in addition, even if the case does come to a conclusion, the case is never really, in fact, over.
In workers' comp, that's fairly unique. A lot of other cases are over when they're over. But, well, first let me say that every level that a party pursues, Appellate Commission, Court of Appeals, Supreme Court, can be another year before that process is done. But once that process is done, and it's usually done before the Court of Appeals and Supreme Court, because both sides usually agree not to take it farther than the Appellate Commission. But whenever it's done, then the winning party gets to enjoy the ruling as it stands then, except, and here's the fairly unique thing about workers' comp, as Jim hinted at, it's never truly done. Because let's say you, the injured worker, win at trial. The employer disagrees and they keep pushing it. It's another 3 years till they're done with the Supreme Court saying, no, we disagree with you, we're gonna let the worker keep their award. Now, in the meantime, by the way, you've only gotten paid 70% of your ongoing benefits. That's the rule for appeal. So when appeals are done, if you're still the winner, injured worker, you're gonna get a nice back payment check of the 30% and perhaps some other monies owed you from before trial also. But here's the main point that I think Jim was trying to get me at, and I'll finally get there. Even if you've won all that time, injured worker, and the magistrate's order says an open award for the foreseeable future, the employer or insurer still has the right to talk a magistrate into thinking that your circumstances have changed and you no longer deserve the benefits. They can send you into one of those one-shot doctors again. Or, heaven forbid, they get hold of some more recent treater documents and perhaps they show a vast improvement of your condition. Perhaps they've ordered some new surveillance. See, your guard is down now because you've done with all the appeals, you think you're home free. They order some new surveillance those 3 years later that find you doing jumping jacks. They have the right to go back to start a whole new case in the Workers' Compensation Court of saying, you know that open award you gave to Frank, it's time to cut it off.
And that happens frequently. These cases generally aren't just forgotten about by insurance companies or claims administrators.
But often not because they really think they could win at a new trial. It's because they don't like the perspective of having to pay you the rest of your life and they're trying to force you into settling.
Speaking of the rest of one's life, as an injured worker who's receiving workers' disability compensation becomes older, sometimes there's intersection with other benefits like pension or Social Security old age benefits. Talk about that and how that affects workers' compensation.
Well, there is a direct offset for old age Social Security.
Yes.
In other words, you can't double dip with that either. Now, there's also, and you'll have to refresh me because this is more of a plaintiff's bailiwick that I'm just getting back into. There's a choice within, they can take 50%.
Yes.
Help me out.
In short, the claims administrator for the insurer or third party can reduce by 50% of the Social Security old age benefits, or alternatively start taking 5% each year from 65 up to 75, in which case it caps and you never get less than 50%, except a court ruling several years ago now said that the insurer or claims administrator can, after making one election, change elections when it's more advantageous to the insurer or claims administrator. So it can say, when someone's 66, take 50% of the old age benefits, and when someone's 75, change directions entirely and say, we're going to reduce your workers' comp by half, because that gives us more opportunity to erode your benefits than taking 50% of the Social Security old age. We're really talking inside baseball kind of stuff, but I think what's important to apprehend is that when the injured worker becomes older, it becomes increasingly complicated to settle her or his case by a lump sum.
And one type, or in one way or another, the workers' comp benefit can be reduced by Social Security.